Welcome to the first ever MACRS webinar. On behalf of the entire executive board, we hope that each of you, your staff, coworkers, and families have managed okay during these challenging months. Together, we have created a new normal for operating retirement systems. Despite a global pandemic, all of the Commonwealth retirees received their monthly retirement allowances without delay, and the boards have continued to be operational. While we would much rather be together, we know that for the foreseeable future, it is not feasible. Instead, we have embraced technology to help us navigate safely. Over 250 people registered for today's legal panel, which is being broadcasted live from the training room at the Middlesex County Retirement System. Please know that we have set up the room with the use of multiple podiums and cameras to adhere to physical distancing protocols to keep our presenters safe. Those of you participating by video which should only be used by those that have specific questions for the legal panel. The written presentation is available on the MACRS website, macrs.org. Registered board members will receive 3 educational credits for viewing the webinar. Please be patient as PERAC adds the credits to Prosper in the coming weeks. After today's session, each of you will receive a survey, which will be instrumental for us in planning future events. I want to thank each of you in advance for taking the time to complete the survey as soon as possible. Now, without further delay, I have the great pleasure of introducing our moderator, Attorney Tom Gibson. If there is possibly anyone in our community that does not know, Tom is the chairman of the Middlesex County Retirement System, the founder of the law offices of Thomas F. Gibson, and board member of the Belmont Retirement System. Tom is a graduate of Boston College and Suffolk University Law School and has always been a familiar face at MACRS's conferences, always willing to volunteer his time even during a pandemic. Tom?
Thank you, Kathleen, and welcome to all of the attendees. This is a brave new world that we are operating in, but I think this is going to be the new normal. We deeply appreciate MACRS is asking me to moderate this panel. It's been a great honor for me over the years to assist in assembling the legal panel and selecting topics that are timely and of interest. And as I've always said, if the board members and staff can come away with 2 or 3 nuggets of information that will help them do their job better, then this panel will be worth the time and the effort to put together. So as those of us who have been around for a little bit, from the pre-PERA days to the creation of PERA in the 80s and PERAC in the 90s, and the latest wave of pension reform in 2009, 2010, and 2011, we are aware that the law is constantly evolving. And this is one of the best ways that we know to let our board members keep up to date on the changes in the law, which is, of course, is constantly changing. So today we have a stellar panel that is going to present to you. Our first speaker will be Judith Corrigan, who is no stranger. Judith has been with PERAC since 1999 and is currently its general counsel. She began her legal career at the Appalachian Research and Defense Fund of Kentucky, and an organization which provides legal service to the poor in rural Appalachia. Judith is a member of the Massachusetts, New Hampshire, and Kentucky Bar, and she is also admitted in the federal court in the districts of New Hampshire and Eastern Kentucky and the United States Courts of Appeal for the Sixth Circuit, where she successfully argued a case regarding a coal miner's pension service. She holds a Bachelor of Science degree in journalism from Suffolk and her Juris Doctor degree from the College of William and Mary in Williamsburg, Virginia. Yeah, personally, I would just suggest that we're all fortunate that Judith has spent the last 20 years at PERAC. She continues the high level of dedication to public service, excellence, and the legal acumen that has been the hallmark of PERAC for decades, going back to the likes of Joe Martin and Barbara Phillips, to John Parsons, and continuing to the present. Judith, Ken Hill, Catherine Brady, and PERAC's legal unit, along with Patrick Charles, who was recently appointed to CRAB, have provided tremendous services to all of the retirement boards for several decades. We may not always agree with PERAC, and they may not always get it right, but we should all take comfort in knowing that PERAC will always do the research on an issue and will act in good faith. So without further ado, I will now present Judith Corrigan, who is going to talk about service purchases in the wake of the recent Gomes decision. Thank you. Judith?
I hope everyone can see me and hear me now. It's funny that this should happen this way because we had a webinar last week or 2 weeks ago at PERAC on option selection and beneficiaries. And during that one, I could only see the slides and not myself. So now I can see both. I understand that the audience sees the slides after the presentation. So let me just say what I said before. Thanks, Tom, for giving me the title of this presentation and a direction in which to go. So basically, I'm going to talk about the buyback of earlier non-membership time with a special emphasis on call firefighters and permanent intermittent police officers and the people mentioned in section 4.2b. So as we know, the buyback of earlier non-membership time is sometimes permissible, but is often not permissible. And it's usually done under one of two ways. You buy it back under section 3.5 for a member for service in a board other than the one of which you're currently a member, or 4.2c for service of the same board. Certain conditions must be met, and but generally speaking, those are the two avenues during which by which you buy back time. So the under $5,000 rule, as Tom mentioned, I came to PERAC in 1999, and from 1999 until 2009, you could buy back any time for which you were compensated. And I believe the under $5,000 rule was put in the statute to prevent the traditional, I'm an elected official in a small town for 29 years at $325 a year, and then I get a job at the lottery for the last 3 years. So I think that was the legislative intent behind the under $5,000 rule. And what the under $5,000 rule says is that you can't get credible service for any time on or after July 1st, 2009, unless it's you're elected or employed in a position receiving the compensation of less than $5,000 annually. If you can't get it, if you're elected or employed in a position receiving less than $5,000 annually. In the earlier iteration of this slide, which you'll see later, I had emboldened the word in a position, but that bold did not make it out of PERAC. So I mentioned there were two avenues for the purchase of this non-membership time. Section 3.5, which is extremely limited, and rightly so, and section 4.2c, which has more options. If you could see the slide now, you would see that section 3.5 is basically limited to temporary, provisional, or substitute positions. And section 4.2c lets you buy back time if other conditions are met for part-time, provisional, temporary, provisional, seasonal, or intermittent employees. We have a Venn diagram of the interplay between section 3.5 and 4.2c. And when you see it, you'll see that there's very little commonality here. The only categories of employment that are common between 3.5 and 4.2c are temporary and provisional employment. So, but there was yet another avenue for receiving prior non-membership time. And that's basically what we're talking about today, which is section 4.2b, or should I say the second proviso of section 4.2b, which allowed credit of up to 5 years for certain named individuals who served in certain capacities in the past. And that, of course, is reserve or permanent intermittent police officer, or reserve or permanent intermittent or call firefighter. And this was traditionally credited without cost. And this, as we know, resulted in some odd things happening. For example, a permanent intermittent police officer who was on his list but never got called for anything and never got any payment was still entitled to the 5 years of service. So this is one of the inequities that's been solved by the under $5,000 rule. Traditionally, when you see the slide, note the fifth bullet point, it has traditionally been allowed without cost. And that is because of the language of the statute, which says the 5 years shall be credited. This was true until McAloney versus the Worcester Regional Retirement System and PERAC, which was decided on June 21st, 2013, and is a final decision of CRAB, having been appealed by no one. And in this decision, CRAB for the first time says, look, you have to pay for the 4.2b service. It says you have section 3.5 and section 4.2c. There's a big discussion about that, but you have to make a payment for the thing. We had never before said that you had to pay for 4.2b, and CRAB says, yeah, you have to pay for it. And I didn't think this was going to stand up when it was eventually appealed, but it did. So we get to Grimes versus the Walden Retirement Board and PERAC, which is a very odd case. It's a companion case to Gomes. It was decided by CRAB on the same day. This is the case of somebody who was never paid anything. PERAC struggled with it, and we came up with a $3,000 imputed salary. And when we got to DALA, and we made the $3,000 based on a lot of things, the old 410, the current 85H, we thought we came up with a pretty good and fair amount to base somebody who didn't get any payment but was going to get creditable service. And then we were kicked to the curb by the DALA magistrate. How about $5,000? Because $5,000 takes care of the under $5,000 rule, and we thought that made a lot of sense. So then we get to CRAB, and CRAB said, although both rates appear fair and bear a reasonable relationship to the benefit provided, this creditable service must be presented at no cost. It must be provided at no cost. And so then we're in the position of saying these people get their service for no cost, and then the people get it they have to pay for it, the other people. Speaking of the other people, Gomes, this was a very, very strange case leading to a Supreme Court decision. Gomes was a permanent intermittent police officer in the town of Plymouth, and he actually had worked a significant amount, and he bought back the time from Plymouth, because Plymouth had a rule that you buy back the time. In a 2003 audit, PERAC said, hey, you should have let him have that payment without cost. So they refunded the money to him. And then McAloney came out, and then PERAC said you have to charge him for the money. And understandably, Mr. Gomes wasn't thrilled with this and decided to appeal to CRAB. And CRAB said that the employees listed in section 4.2b are able to buy back service if makeup payments are made equal to what would have been contributed based on the salary paid to them. So the CRAB decision was appealed, and it was appealed by PERAC and CRAB to the Superior Court, where the Superior Court found, look, it says credited in the statute, this man should not be charged. So understandably, PERAC did not appeal this decision. We thought it was the right decision. We thought it was the correct outcome. But it was appealed by CRAB, and CRAB wanted payment made. They said under 4.2c, you have to buy it. So the SJC said, you know what? We agree with CRAB. We think that 4.2b is a measurement scheme only, and 4.2c requires payment. So now under that reasoning, everybody's going to have to pay for this service going forward, and they have been. So there wasn't much, they have been since McAloney, so there wasn't much by way of corrective action that needed to be taken. So in Gomes, however, the SJC talked about the under $5,000 rule, and most people watching the argument heard the Assistant Attorney General mention the under $5,000 rule in his oral argument. And when you get to slide number 11, you'll see footnote 4. that talks about the unfairness of people, some people buying the time and some people getting it for free. And the Supreme Court talks about inequity and finally says further, to the extent that this appears unfair, in 2009, the legislature addressed such outcomes in the new section 410. And in footnote 9, they say, until 2009, the minimum amount of qualifying work for PIPOs was 0. That's what they kept calling permanent intermittent police officers. I don't know if I'm pronouncing that correctly. For so long as they were on call, they could receive credit even if they were never called to duty until July 1st, 2009. So what they actually said in that decision was, in 2009, the legislature reiterated its preference that members, comma, including PIPOs or PIPOs on eligibility lists who were never called into service, comma, remit payments to obtain creditable service by inserting Chapter 32, Section 410, which asserted that, quote, no state, county, or municipal employee, end quote, who earns less than $5,000 starting on July 1st, 2009, can accrue creditable service for that time. I just wanted to add the commas because when we were going through this at PERAC, it has a different meaning without those commas. So as a result of this, we issued PERAC memorandum number 11 of 2020, and we got a lot of questions about this. So we were planning a follow-up memo, and we are about to issue a follow-up memo, but this is kind of a preview of what's going to happen in that memo. So we issued it on January 6, 2020, before lots of things happened in the world. And when you see the slides, you will see that bullet point number 5, the required receipt of $5,000 per year will only apply to the category of employees listed in the second proviso of Section 42B. So I think that's the biggest takeaway from Gomes and from our previous memo. So we got a lot of feedback, and I don't like to call it blowback or pushback, or I love when people ask questions and bring up something we didn't think about internally at PERAC when we're reviewing things for each other, and externally when the boards say, hey, what about this? For example, we had never considered this business of detail pay. I, for one, didn't know PIPO people did detail pay. And we got the first question about detail pay, and I thought, well, this is going to be kind of an odd thing. I would say the most questions we got about Memo 11 was about the detail pay. Now that we have to receive $5,000 a year, can we include detail pay we do as a PIPO? The answer is yes. That is what the next memo will say. I don't know what number the memo will be, but it should be 28 or 29, I'm not sure. So Section 410 refers to compensation, not regular compensation. And it seems like they only get to do the details because of their PIPO position. And so that is the answer to that question. Another question which arose a couple of times, probably 4 times, was does the same department mentioned in the memo apply to both police officers and firefighters? So it does not. As many people know, for the most part, unless you're appointed to the same fire department of which you were a call firefighter, a reserve firefighter, you cannot get the credit under 42B, that augmented special credit. So the same department does not apply equally to police officers and firefighters. With this caveat, if your municipality has accepted the local option contained in 42B.5, then firefighters don't have to be appointed to the same department. As of the writing of this presentation, only 13 cities and towns have accepted 42B.5. The other question we got was, and we got this a lot too, not as much as the detail question, more than the same department question. Why does the memo state that if a member is ineligible to purchase Section 42B time, they will be unable to purchase it via Sections 3, 3.5, and 4.2C? And an opinion letter we wrote in 2015 was brought to our attention, wherein we said that a person who is ineligible to buy back this time could buy it under 3.5 if certain conditions are met. Now, if I I think it would be very hard to get this time to fit into one of these categories and fulfill the $5,000, under $5,000 rule. But if your retirement board can find a way to do it and feels that it should do it, it should do it. We all know the awesome authority that retirement boards have in section 3.2D about part-time, provisional, temporary people. And so it seems very unlikely that you'll be able to fit this time into this niche, but if you think you can, the first thing that we have to do is you'd have to ask under section 3.5, was it temporary, provisional, or substitute? Was the position temporary, provisional, or substitute? I don't know enough about call firefighting to know whether, or PIPOs, to know if they can be so classified. Obviously, if you were going the 4.2C route, there would be more avenues open in terms of the position they played. So, and then you have to ask about the under $5,000 rule. Were they in a position for which the income was fixed at $5,000? Now, remember that this time is not the augmented special time that you got under 4.2B. This time is the actual time that you served being awarded to you. So in conclusion, I would say that the second proviso of section 4.2B has undergone radical changes, at least in my lifetime of 21 years at PERAC. And the paying of service is relatively new with Macaroni, and the under $5,000 rule applying to such positions, such cases, is brand new since December of 2019 with Gomes. You know, the retirement boards in PERAC had not imposed the under $5,000 rule on 4.2B service. We thought it was special and unique and a distinct granting of service. So we'll all continue to adapt. And as I said, our new memo about this is soon to be issued. Thank you for your attention.
Thank you, Judith. We appreciate that presentation, and I just want to remind our audience of a few things. As Kathleen had indicated, the PowerPoint is on the MACRS website. So the next speaker will be making his debut on the MACRS legal panel. Matt Feeney works for Murphy, Hesse, Toomey, and Lehane. He heads up their Chapter 32 public retirement practice and is well-versed in all matters pertinent to Chapter 32. He provides frequent guidance to public retirement boards relative to the many member-related issues that arise. Matt is a graduate of Boston College and Boston College Law School, so he's a double eagle. If he had gone to BC High like I did, he would be a triple eagle. But unfortunately, that didn't happen. So Matt is going to talk about COVID-19 and Chapter 32. So without further ado, Matt.
Thanks, Tom, for the introduction. Appreciate it. Good morning, everyone. I'd like to thank MACRS for inviting me here today, particularly President Kathleen Kiley-Bacchetti. The topic I'm going to be covering today is COVID-19 and the impacts that it has had relative to Chapter 32. Obviously, COVID-19 has had enormous impacts on all aspects of our life, personally, professionally, what we do, how we do it, who we do it with. The changes and the impacts have been dramatic throughout the world. Obviously, professionally, it has impacted the manner in which we can work, the manner, where we work, particularly, is evidenced by what we're doing here today with this virtual presentation. So the focus, what I'd like to do today in discussing the impacts of COVID-19 on Chapter 32, I'd like to kind of discuss some of the procedural impacts as well as some of the substantive impacts that COVID-19 has had relative to Chapter 32 law. So beginning with procedural issues, there were two things that kind of jumped out at me when I thought about what potential topics could be for today. One just deals with the general slowdown that has occurred as a result of COVID with the practice in matters before retirement boards. And the second issue deals with some of the changes regarding the open meeting law. So beginning first with just the general aspect of slowdowns that have occurred. Obviously, when this whole thing started, things developed in happened very quickly, frankly, and retirement boards were forced to adapt, hopefully as quickly as they could. That being said, with the fact that members who were going through the disability process, for instance, were unable to get medical panels, a significant backlog began to build. Now, there has been attempts by the relevant agencies, particularly PERAC, to try adjusting to these new issues that we find ourselves in. And one of the things that they tried doing was the telemedicine panels, which obviously have been very helpful in that some members have now been able to get their cases moving through the retirement system rather than just being completely bogged down as they were prior to the telemedicine. While it's obviously not a panacea, it's been something helpful. I know some of the numerous members of the boards that I represent have been able to use these telemedicine appointments to get their regional medical panels completed and move on with the disability process. Now, as I said, telemedicine is not a panacea. There are certain issues that come up with telemedicine, and one of the first issues deals with the fact that you need all three parties involved to consent to that. So that would be the member, the retirement system, and the employer. Any one of those three people who does not agree with that can essentially veto the request of a member if the member is so inclined to try doing telemedicine. So as I said, it's a potential issue. I know certain employers aren't comfortable with it, and I know certain members have not been comfortable with it. And transitioning to the how comfortable a member would be with telemedicine appointments, I think the reality is that there's a certain question of feasibility of telemedicine for certain types of conditions and disabilities. While telemedicine seems to be something that is very conducive to disability applications relative to perhaps the heart law, the lung law, the cancer law, where a medical review is going to be essentially medical records and not much else, it becomes a lot more complicated when you start thinking about having to do a physical examination for someone's back, for their shoulder, for their knee. So I think there has been, from some of the attorneys I've discussed representing members, there's been somewhat of a reluctance to use these panels for certain types of conditions. And those are the conditions which I think boards most generally see. You're talking about the knee replacements, the rotator cuff surgeries, disc issues in the back, and issues with the spine. So obviously, as I said, it's no panacea, but it is something that hopefully people have been able to use throughout COVID to move their process along. Obviously now we have medical panels back up and running, so hopefully the backlog that has occurred can start being hopefully slowly withered away. Now, moving on to the next procedural aspect that kind of jumped out at me when I was thinking about topics for today, it's the open meeting law. Obviously, the open meeting law changes that have occurred stemmed initially from the governor's emergency order and eventually were codified on April 3rd with the Act to Address Challenges Faced by Municipalities and State Authorities Relating from COVID-19. This is the open meeting law as it's applied to Chapter 32. Obviously, it applies across all public bodies within the Commonwealth. It's not just for retirement systems, but there are certainly certain issues that specifically apply to the new open meeting law conditions as applied to Chapter 32. And the first thing that I thought of, the first issue that I've personally experienced in the boards that I've represented is the idea of privacy during the executive session of board meetings, specifically when dealing with disability applications. Obviously, a member, if he or she so chooses, could have their hearing be public, but obviously most members prefer to have their hearings in private. And just the logistics of trying to make sure that a member is having a private setting represents problems. Obviously, the platforms that are being used, whether they be Zoom or GoToMeeting or one of the numerous other platforms that are being used during COVID, allow for the ability to monitor who can come in and out of the meeting, but it still creates logistical difficulties, particularly if you were trying to have multiple people come into an executive session. So it can slow down a process that's already somewhat difficult to begin with. And I think a greater issue with the change to the open meeting law and the fact that boards can meet virtually during this pandemic deals with the idea of credibility of witnesses. How do you make these determinations? In these disability hearings, and in other hearings that a board is going to conduct, the single most important thing that a board member is going to try doing when trying to reach a conclusion is to determine the credibility of the people who come before them to testify. Credibility is a very difficult thing to do over video. There's certain things that you can't really notice. You can't notice what people are doing with their hands, what people are doing with their feet. Sometimes I've been participating in calls, in meetings rather, that were just over the phone. So you cannot even have any sense about what someone is doing relative to their, what their facial gestures are. So it's something that obviously is very concerning for boards. And I think everyone is just trying to do the best you can with it. But right now we're in a virtual world, and these are the realities with which we must face. Now, I've had conversations with certain members in the retirement community dealing with the idea of trying to get people back into the board meetings live, so you can make these credibility determinations and have a smoother process than what we are currently doing now. Although everyone is trying to work as well as possible. But it's something to consider, is that while the desire to bring people back into live settings, even maybe if it was some sort of hybrid setting during this crisis, considering the type of situations and conditions that members find themselves in for these disabilities, you often would have the most vulnerable people trying to seek these disabilities. So these particular people are not probably the people you want coming back into your meetings, despite your best wishes and hopes to try having these meetings be live. So I think it's a very delicate balance right now when trying to consider what the best steps are. But as of right now, the hearings are virtual, and everyone's just going to have to keep doing this probably for at least the next few months. So I briefly discussed some of the procedural issues that are relevant to the changes that COVID-19 has forced upon Chapter 32 law. Now I want to move to some of the more substantive changes that are applied to Chapter 32. The most obvious change jumps out in the is that regarding Chapter 91B and C of Chapter 32, which deals with over-earnings, as far as the 960-hour rule. Based on the legislation that has been passed by the Commonwealth for the time period during the emergency. So I think going back to March and through until it ends, the 960-hour rule will not apply to retired public employees who are currently employed in the public sector. Obviously, I think we can anticipate that will change, and those hours will start counting back towards Section 91 once the pandemic is over, but we are certainly not there yet. Now, the next thing I want to discuss is just very briefly regular compensation and credible service. The slides that you will have go into the definitions of regular compensation and credible service. And it's important to consider these definitions because they have relevance to the next topic, which I'm going to discuss. I won't belabor the full definition of regular compensation. I think most people are very familiar with it, but we're generally just talking about the salary and wages that one person receives for the work that they do for a particular public body. And with credible service, generally speaking, it is something that you get service for the work that you do, and that you can still even get credible service if you are absent from your job but still receiving full regular compensation. So there is definitely an interplay between the definitions of regular compensation and credible service. So in light of those two definitions, regular compensation and credible service, I think it's important to now consider some of the federal legislation that has been passed. And it's kind of an alphabet soup of acronyms here, but the Federal Family First Coronavirus Response Act, the FFCRA, is effective April 1 of 20 through 12/21 of 20. Who knows if that will be extended? Hopefully it's not necessary, but who knows? This act essentially provides for COVID-19 related leave, and there are two separate leave acts that I'm going to discuss today that are relative to this legislation. The first is the Emergency Paid Sick Leave Act, which is the EPSLA. And this applies to 6 different scenarios in which you can get up to 2 weeks of paid leave for full-time employees. The second is the Emergency Family and Medical Leave Expansion Act, the EFMLEA. This particular act just adds one particular scenario to FMLA coverage. So it's an expansion of what previously existed for FMLA. And I will get into the different scenarios that I previously talked about for both the EPSLA and the EFMLEA. Easier to say, I guess. So the EPSLA can be used by employees who are one of the 6 following reasons: subject to federal, state, or local quarantines. They've been advised by a healthcare provider to self-quarantine. They're experiencing COVID-19 symptoms and seeking a medical diagnosis. They're caring for an individual who is subject to the first exception or reason, or is advised to do as the second reason discusses. The 5th reason is if you're caring for a child whose school or place of care is closed or unavailable due to COVID-19, and the 6th reason is for if you're experiencing similar conditions as specified by HHS, which is the Federal Health and Human Services. Now, for the EPLSA, this percentage of pay depends on the circumstances of leave. So for scenarios 1 through 3, your pay is 100%, and it's capped at $511 per day. And for the scenarios 4 through 6, your pay is 2/3 pay, capped at $200 per day. So if you look at those 6 previous scenarios, 1 through 3 is 100%, and 4 through 6 is 2/3 pay. Now, transitioning to the EFMLEA, this can be used for employees whose school or child care provider is closed or unavailable due to COVID-19. So it mirrors one of the previous scenarios under the other act for leave here. Now, in this particular scenario, while the previous act was for 2 weeks of paid leave, this is a much longer period of time that is available. However, the first 2 weeks of leave here are unpaid. However, you can use EPSL time or other accrued time for those 2 weeks. And then the next 10 weeks are paid at 2/3 of your salary at $200 per day for full-time employees. So essentially, this mirrors the FMLA requirements, in which you can get up to 12 weeks of leave for given reasons. There is going to be a slide here which kind of lays out how things go from the FFCRA and what the kind of not requirements are, but the scenarios that occur for the EPSLA and the EFMLEA. And you can review those slides at your leisure. Now, one thing that's kind of relevant now to what's happening with COVID-19 is the idea of teleworking, telecommuting, whatever the phrase may be. Now, in this particular scenario, generally telecommuting or teleworking is going to be, you're not going to be able to use the FFCRA unless there are certain extenuating circumstances that might exist. So if you're working at home, you just can't automatically use the FFCRA in one of the 2 acts that are there, unless, as I said, there are certain extenuating circumstances. I would note that PERAC Memo 27 references one of those potential extenuating circumstances when, under EPSLA reason number 3, the employee is too sick to telework, and he or she could then get the benefits of one of the acts of the FFCRA. Now, when you look at those 2 acts, the EPSLA and the EFMLEA, I just want to now turn to the idea of once, as we previously discussed, regular compensation and credible service, and how do those 2 items work when you're dealing with this federal legislation. Well, PERAC memos number 20 and 27 of this year, and 27 just came out a couple days ago, opine that the EPSLA leave is regular compensation that entitles an employee to creditable service. So obviously there's no issue there. And while I don't believe that there has been, at least that I'm not aware of, any specific reference to the EFMLEA, I would imagine that the same logic would apply, in that they would both count for regular compensation and credible service if you were indeed being paid under one of these acts. But perhaps Judith can correct me later on if necessary. So Chapter 32 also, where you discussed the some of the scenarios that are relevant today. And one thing that I know a lot of people are going through is our furloughs. So furloughs are going to be that you haven't been fired, you haven't been laid off, you are still technically employed, but you've been essentially given an unpaid vacation for an extended period of time. So there's a question of whether or not, if you were on furlough, would you be able to get credible service for that time while furloughed? It would seem that because you're not receiving regular compensation at that time, that you would not be able to have credible service for that scenario. Unemployment benefits would not appear to count. And there's a case that's cited for Boston Retirement Board v. Crabb from 2004, which would seem to be an appropriate case. It's a Section 91 analysis, but it discusses earned income requiring services for actually performed. So in this particular scenario, obviously, if you were receiving unemployment benefits, you would not providing any services. So it would seem very unlikely that you'd be able to get creditable service if furloughed. The last thing I want to transition to now is COVID-19 and accidental disabilities. In terms of the question for COVID-19 and accidental disabilities, can it be a personal injury, COVID-19? Turning to the workers' comp law, which is often referred to in the Chapter 32 world, personal injury could be an infectious or contagious disease. I think it will depend on several things, and there's certain cases that are referenced in the slides which talk about examples from the comp world in which someone got an infectious disease, in this case tuberculosis. One was inherent in their employment and one was not. So these are potential cases that would be helpful to look to as far as how COVID can work moving forward in the ADR world. And the last would be if you were injured while teleworking. Potential issues with these types of claims could start arising. Issues that could be lack of eyewitnesses, credibility determinations, and also performance of duties issues. How was someone in the performance of their duties while at home, while working? So these are issues that are going to develop potentially over the next several months, and we could be dealing with this for some time. Obviously, the impacts of COVID-19 have been dramatic. This will be a temporary situation, but we could have lasting impacts for the Chapter 32 world. So I'd like to thank you for your time. If there are any questions, you can submit those to the chat, and I look forward to hopefully seeing you in person at some point in the near future. Thank you.
That was very present. Okay, thank you, Matt. That was a very instructive presentation and very well done. And I'm sure that you can have a few questions from the attendees on some of the impact of that. And as I mentioned earlier, we will take all of our questions at the end of the presentation. So our next speaker, who's going to talk about a case study on Section 15, the dereliction of duty, is Lisa Maloney. Lisa, as you know, is the Chief Administrative Officer here at the Middlesex County Retirement System. She's been in that position since July of 2016. Prior to joining our retirement system in 2015, Lisa served for more than 16 years at the Massachusetts Teachers Retirement System in diverse supervisory roles. Lisa was a graduate of Wellesley College and American University's Washington College of Law. Lisa also worked in the private sector as a medical malpractice defense attorney until she decided to come back over to the right side in public service, which we're all grateful for. Lisa was a member of the National Association of Public Pension Attorneys and just recently completed her 2-year term as president of the Massachusetts Association of Public Pension Attorneys. Lisa was also a member of the board of the Blue Hills Regional School Retirement System. And personally, I have to say it's a privilege to work alongside Lisa here at Middlesex. She has a work ethic that is unmatched. So without further ado, I'm going to turn this over to Lisa Maloney.
All right. Good morning, everyone. It's nice talking to all of the thumbprints that I see on the screen instead of the full bodies in the audience. But as Tom mentioned, I am going to talk about forfeiture this morning. It has been covered extensively, I know, by this panel. And in fact, two of the speakers here today, both Judith and Michael, have spoken about it. So what I'm going to do today, I hope, is a little different and focus primarily on the misappropriation of funds, a case study that actually came before the Middlesex County Retirement Board for an employee who was suspected of misappropriating funds but passed away prior to being charged. So the first thing I'm going to do is just briefly give a recap of the forfeiture provisions. It's well established that certain wrongdoing by a member could result in the loss of a retirement allowance or refund to either the member or the beneficiaries under certain circumstances. So there are four main forfeiture provisions as I see it in the forfeiture statute. The first, 15.1, addresses recovering funds from an employee who is charged with misappropriating funds or property. This is the so-called civil forfeiture provision. The next section also deals with misappropriation of funds or property, but it requires a final conviction for the forfeiture proceedings to be triggered. That's section 15.3. Section 15.3a addresses what happens to employees who are finally convicted of specific crimes that are listed in the statute, either ethics violations or extortion. That too, upon final conviction, will result in a forfeiture of benefits or refund. And then 15.4, which is the topic that has been well discussed, forfeiting the right to a retirement allowance after final conviction of a criminal offense that is factually or legally linked to the employee's office or position. So with that, by way of background, I'm going to circle back to the first provision I mentioned, the civil forfeiture provision, and talk about how those forfeiture proceedings get initiated and the consequence if that's triggered. The first, if a member has been charged with misappropriating funds, they may make a written request to the board for a hearing. With that hearing comes certain due process considerations. They have now the opportunity to be heard, present evidence on their own behalf, or otherwise dispute the charges. The second way to trigger the civil forfeiture proceedings is for a third party to do it. The board, the department head, Board of Selectmen. If they initiate proceedings against the member, those due process considerations that I just talked about kick in here as well. The member must be given notice of the issue, the opportunity to be heard, present evidence, cross-examine witnesses that might be brought by the proponent. And they also have the ever important right to judicial review. So simply put, for these civil forfeiture proceedings to be triggered, the member must be given notice of the issue, an opportunity to be heard before any benefit for either themselves or their beneficiary will be lost. Now, what's the consequence of the civil forfeiture proceedings? Well, if after hearing the board finds the charges to be true, then no retirement allowance or refund will be paid to the member or their beneficiary until the restitution of the misappropriated funds are made, and they also have to pay back any investigative costs if there were any. So what I want you to note here is that this is actually remedial. It's focused on restitution. The members and the beneficiaries do not lose their entire benefit, only the amount needed to make the governmental unit whole. So with that by way of background, I'm going to tell you about the case that came before the Middlesex County Retirement System. We had a member who was the finance director in a town for almost 13 years. She left that position and became the finance director in another town within Middlesex County Retirement System. And after she left, the treasurer, in the normal course of business, treasurer of the first unit, uncovered some questionable transactions on the town's credit card that was in the possession of the finance director and which she had to use in her capacity as the finance director. The treasurer called the former employee to ask about some of the charges, and the explanations provided were questionable, vague at best. So the treasurer brought the matter to the interim town administrator and the chief of police. The investigation was opened, and a detective that was assigned to the case spent several months documenting and uncovering improper transactions on the town's credit cards totaling at least $96,000. There was charges for clothing, travel, sporting goods, and the purchases were hidden in the general ledger by misrepresenting what the expense was for. On the day the member was to be interviewed by the police, the member was a no-show, and it was later discovered that she had died by suicide. So the media outlets were the first to notify us of this case. In fact, I was driving back from the MAPA meeting last summer when my staff started calling because this is somebody that we knew personally, that we worked with regularly, who had come to this office for training. And we were all sort of shaken and in a state of disbelief that this was happening. And then we were notified by the town formally that they had strong, if not overwhelming, credible evidence by way of bank statements and receipts that this member was in fact misappropriating funds for her personal use and benefit during the course of her employment. And the town asked whether they could initiate forfeiture proceedings against their former employee who is now deceased. While all of this is going on, as an active member, this employee named her surviving spouse as her 12(2)D beneficiary. And for good measure, there were dependent children from a first marriage in the mix who might have been entitled to the dependent child benefit. So the board now is left with, what should we do? Should the town receive restitution? Had the member not committed suicide, the town firmly believes that charges would have been brought, that the employee would have been convicted, and that forfeiture of the benefit would have been the result, and the town would have received restitution. Or should the board process the application for member survivor benefits for the surviving spouse and the dependent children? On one hand, it seems that the member's death stops everything related to the forfeiture. On the other hand, should the spouse and the dependent children receive benefits and get their claim untouched when the town is owed money, and we also don't know whether the family benefited from any of the transactions that were discovered on the credit card. So what does any good board member do? We write PERAC for a technical advisory, and we ask PERAC, what would you do in this situation? PERAC and the board, it was easy to rule out, if you will, the provisions in the forfeiture statute that require final conviction. The member has died. She can never be prosecuted or convicted. So those parts of the forfeiture statute will never be triggered. They're triggered by a final conviction, and that's never going to happen. So what we were really focused on was those civil forfeiture provisions that I talked about. And if you recall, I said it could be initiated two different ways. One, by the member making a written request for the hearing, or two, the third party initiating the proceedings. Are either of those feasible? Well, the member has died, so she's not going to be able to request the hearing. So the board is essentially powerless to do anything there. Can the third party do it? Well, assuming the former employee could initiate, assuming the former employer could initiate proceedings against the employee, those due process considerations and procedural safeguards that I had mentioned earlier about the notice and the opportunity to be heard and the right for judicial review are not available to this member either. So it seems that even the civil forfeiture provisions of the forfeiture statute are rendered inoperable as well. So in fact, that is what PERAC concluded. They ordered us to process the surviving spouse's application for member survivor benefits. The dependent children are receiving their relevant benefit. And really this conclusion is in line with PERAC's longstanding position that benefits paid to a beneficiary following the death of a member remain unaffected or untouched by what the member might have owed the retirement system prior to dying. So thank you for your attention. If you have any questions, please use the chat room.
Thank you, Lisa. That was excellent presentation on a very sad situation. And unfortunately, we're seeing throughout the Commonwealth these cases of employee embezzlement from their employer, which speaks about the checks and balances that go on within town halls regarding oversight of payments made, cash payments made, et cetera. The temptation is there for desperate people to do desperate things. And unfortunately, it arrives on the doorstep of the retirement board from time to time. So our final speaker today is well known to everyone in the retirement community. Mike Sacco was recently appointed to be the Worcester Regional Retirement System's Chief Executive Officer. This happened in January of this year. Michael is the founder of the law offices of Michael Sacco, and Michael in the law office serves as legal counsel to more than half of the Commonwealth's retirement boards. Michael is now in his 37th year of working for and representing retirement boards. And I remember when Michael was just a rookie on the block. So you've come a long way, Michael, for sure. And he's been involved in so many cases that have shaped how the retirement law here in Massachusetts is interpreted. And he has argued successfully before the Supreme Judicial Court 6 times on various retirement issues. He is a graduate of Boston College and also Suffolk University Law School. Michael is going to talk about 2 cases that he was recently involved with that should be of great interest to the retirement boards who are listening here today. So Michael.
Thank you, Tom, and it'd be nice to see everyone in person when we can get through these difficult times. I'd like to speak to you about 2 cases today. The first is styled as Franklin Regional Retirement Board versus CRAB, which the underlying case was Elizabeth Bell versus the Franklin Regional Retirement Board. It is a accidental death case, and I think it illustrates some of the tools that are available to retirement boards in processing accidental death claims. The underlying facts of the case: David Bell was the chief of police in the town of Deerfield who retired for an accidental disability under the Hart Law in 1994. In 2013, April 23rd of 2013 to be exact, Mr. Bell died. When he retired under the Hart Law, his diagnosis was coronary artery disease. And when he died, his death certificate listed congestive heart failure and diabetes mellitus as the causes of death. On its face, congestive heart failure is not coronary artery disease, and we did not initially receive an application for accidental death benefits from Mrs. Bell, but in January of 2015, she did in fact file an application for accidental death benefits. The board's policy, which is one that I utilize with many of my clients, is that where it's not clear on the death certificate that the cause of death and the reason for retirement are linked, the 5-year previous medical records for the individual, as often is the case, the medical records will address the cause of death and what was going on with his underlying medical conditions. Even though a death certificate is prima facie evidence of cause of death, it is not irrebuttable, and certainly other evidence can be considered in determining cause of death and whether there's any causal relationship between disability and death. The medical records in this case, particularly those in the 5 months preceding Mr. Bell's death, indicating that he had 19 different diagnoses. He was a very ill man. Those diagnoses included acute heart failure, interstitial lung disease and pulmonary fibrosis, diabetes, chronic kidney disease, and of course, coronary artery disease. Mrs. Bell, in applying for benefits, submitted a letter from a doctor. His name is Dr. Campanile, and he said that Mr. Bell died from congestive heart failure and he had significant heart disease. That does not satisfy the natural and proximate cause requirement in Section 9 for an accidental death benefit. So the board went and sought an independent opinion from PERAC and asked that they appoint a single physician to review Mr. Bell's medical records and to offer an opinion as to the cause of death. As you know, at that stage of an application, we're not in an adversarial posture, so we wanted to make sure that Mrs. Bell was given every opportunity to present her claim, and given that her own physician statement was somewhat lacking, the board wanted to explore having a PERAC physician review the case. So Dr. Weinrock was appointed, and his opinion, unfortunately, was not very helpful. He had indicated that Mr. Bell died as a result of both cardiac and pulmonary disease, and he said there was no reason to rebut the opinion that Dr. Campanile had provided, which of course was not the question that was asked of Dr. Weinrock. He's supposed to give his own independent independent opinion, not comment on someone else's opinion. So what the board did was it took the measure of going out and retaining its own physician. Retirement boards have the ability to retain their own counsel, their own doctor, pursuant to Section 20, subsection 5, subsection D. And the board retained Dr. Gregory Giuliano for that task. He was a Bay State cardiologist in Springfield. And Dr. Giuliano reviewed the records and he opined that the cause of death was, in fact, Mr. Bell's pulmonary condition based on his review of the medical records. And based on Dr. Giuliano's opinion, the board denied the application and Mrs. Bell appealed to DALA. DALA reversed the board's decision, essentially finding that Dr. Campanile's and Dr. Weinrock's opinions were sufficient to establish the causal relationship between the cause of death and the retirement. And she discounted Dr. Giuliano's opinion because he had not examined Mr. Bell, although we pointed out that neither did Dr. Weinrock, but that was not persuasive. And DALA awarded Mrs. Bell accidental death benefits. The board filed objections to that decision. CRAB, in a very brief decision, essentially accepted the findings of fact that DALA magistrate had made, accepted them, and found that the DALA decision was correct without any further comment. The board was not in agreement with the CRAB decision or the DALA decision. And again, not in agreement because they didn't want to pay the benefit, not in agreement because they didn't feel the evidence warranted that they pay the benefit. So the board filed a complaint in Superior Court. We argued that out in Franklin County. We were very fortunate to draw a newer judge to the bench. She had been recently appointed. Oftentimes with judges who have been sitting in the Superior Court for an extended period of time. Also in Western Mass, they don't see a lot of retirement cases. It's very easy for them to review the case, accord CRAB the deference that it's entitled to under the statute and the case law, and approve the decision. She did not. She essentially embraced the board's position, found that the CRAB decision was both unsupported by substantial evidence and erroneous as a matter of law. Essentially, what she found was that neither of the doctors upon which the DALA magistrate relied addressed the underlying pulmonary condition that was clearly impacting Mr. Bell's health. She also pointed out that the death certificate did not say that he died of coronary artery disease. It said congestive heart failure, which Dr. Giuliano had presented in his letter to the board, that those were not the same conditions. And finally, the Superior Court judge also said that the magistrate did not adequately address why she disagreed with Dr. Giuliano's opinion, which was fairly concise and on point. So the matter was remanded back to DALA. Now, in your materials, you'll see that we did litigate this case back in January before the pandemic hit. We brought in Dr. Giuliano as a witness. He testified. He was spectacular in his presentation, extremely detailed, but he spoke in a way that anyone could understand in explaining the condition that Mr. Bell had. Essentially, with his pulmonary condition, he had a condition that his lungs were so poor that a condition called honeycombing had occurred, which is pretty much exactly what it sounds like. The tissue in the lungs, which generally are soft and contract and expand as one breathes, had become so hardened they were like honeycombs. And he was very compelling in his testimony. There was no other testimony presented, and just recently we received the DALA decision. We were before the same magistrate, and to her credit, she accepted Dr. Giuliano's testimony and reversed herself and found that the board had acted appropriately in denying the application. Mrs. Bell did file objections to CRAB, so this case will be ongoing, but I think this case illustrates that the discretion a retirement board has. You always are able to retain your own physician, whether it's on an accidental disability or an accidental death case. And there are certain circumstances, and this was certainly one of them, that it's appropriate to do so. Again, the board did this not because they were looking for a way to deny the benefit, but because they were dissatisfied with the quality of the opinions that were presented to them. And as with any claim for benefits, the board's singular responsibility is to make sure those who are entitled receive the benefit and those who are not entitled do not get the benefit. So this will be an ongoing case, and hopefully in future conferences, I will speak to you about this in person and let you know how it turned out. The second case is Robert Hollop versus the Worcester Retirement Board. I'm going to go through this case somewhat quickly in that, and not in a lot of detail. Ultimately, this was a 46-page CRAB decision, which was several years in the waiting. And as I remarked when I received this decision, as many of you know, we've not received CRAB decisions in a very timely manner through no fault of their own. They meet infrequently. There are many, many cases that they have to decide, but my comment at the time was if these are what the decisions are going to be like, then it's certainly worth the wait. Underlying facts, Mr. Hollop was hired in the city of Worcester in January of 2003 as a sanitation worker. Now, when they hired him, he had a history of ADD, attention deficit disorder, ADHD, which is attention hyperactivity disorder. He had anger issues, he had alcohol issues, he had drug use issues, and he had been arrested for assault and battery. He was a fairly volatile personality. In September of 2004, after only being on the job for less than 2 years, he suffered an injury where he fell off the garbage truck on which he was riding. His job in the sanitation department was to ride in the back of the truck and to pick up trash around the city of Worcester. What exactly happened is not clear, and that is because the story that Mr. Hollop told, and there were no eyewitnesses to the actual injury, varied over the many years that he was treated and examined, ranging from he was stepping off the truck and stepped into a pothole, tripped and fell back and hit his head, to he was hanging on to the pole on the side of the truck for dear life as it was traveling 30 to 40 miles an hour and got flung off the truck and thrown into a retaining wall. What we do know is that he did fall off the truck. He did have a laceration to his scalp, which was less than an inch, required 6 staples to close at the hospital where they took him following the injury, at which time he was evaluated. They did not find any intracranial bleed or any extensive head trauma other than the laceration, and he had indicated that he did not lose consciousness at any time from the time that he fell to the time that he had been put in the ambulance and arrived at the hospital. So What happened over the next 7 years was quite an odyssey. Mr. Hollop filed for accidental disability 3 times. The first time that he filed was based on a neurological condition. The neurological panel answered no to the first question. They said that he didn't suffer from a neurological incapacity. He did not, the board denied that first application based on the medical panel opinion as it was required to do. And Mr. Hollop did not appeal. He filed a second application claiming a psychological incapacity, but it was based on the same physician statement that he submitted with the first application. Board gave him an opportunity to supplement that application with a new physician statement. He did not do so. So the board considered that application and denied it, and there was no appeal taken on that application. The third application, again, based on the same injury, was based on a psychological condition that he claimed to have suffered as a result of the head trauma. And that went forward. And Mr. Hollop was examined by a 3-member medical panel, all of whom answered all 3 questions in the affirmative, indicating that Mr. Hollop did suffer from a psychological incapacity that was permanent, and that it was such as might be the natural and proximate result of the injury he suffered in September of 2003. And this examination occurred in 2011. It had taken 8 years between the time of injury and the time of the medical panel to decide. The Worcester Retirement Board looked at the evidence before it, and they denied the application. The basis of the denial was essentially threefold. One, that Mr. Hollop did not prove that he suffered from a psychological incapacity at the time he last worked back in 2003. Second, that the medical panel that examined Mr. Hollop was not given the correct information from Mr. Hollop when he was examined. And third, there was insufficient evidence to link the actual injury to the permanent incapacity. Mr. Hollop appealed and went to DALA, and DALA found that Mr. Hollop had sustained his burden of proving an entitlement to an accidental disability retirement. The magistrate found that it was inconsequential, that his story changed from time to time with respect to the treating physicians that examined him, as well as with the medical panel, and essentially said something happened. No one disputes that something happened on that date. The medical panel said he's disabled, and then it's related to the injury, and she decided to grant him the benefit. She also found, which was somewhat pivotal, that the fact that he was in anger management, and he was in anger management both before and after the injury occurred, was not considered past psychological evaluations, which was one of the issues with his representing to the medical panel that he hadn't had any treatment for any psychological issues prior to the injury. So as I noted at the outset, we went to CRAB, and after a couple of years of waiting for a decision, CRAB wrote a 46-page decision, which I would encourage all of you to read. All the cases that I've discussed today made reference to, all the cases that I've referenced today have been provided to MACRS, will be on the website for you to take a look at. It really is a fantastically written decision, not because it agreed with our position, but because it was just extremely well done. What we had done in the objections was to essentially deconstruct most of the medical doctors' opinions who had examined Mr. Hollop and based their opinions on faulty evidence. And a medical panel opinion, or any medical opinion, is only as good as the evidence upon which it is based. And so CRAB did a really nice job in outlining all of the deficiencies in the medical panel opinions. And they also, based on the VEST case, which I think many of you are familiar with, the VEST case stands for the proposition that an individual who seeks a disability retirement sometime after he stopped working, which invariably everyone files for a disability after they've stopped performing their duties, but they have to prove that they were permanently incapacitated for the same reason that they're later seeking a disability retirement. And given that Mr. Hollop had an extensive psychological history, and there was no indication that anything that occurred during that injury that aggravated his condition, they found that there was insufficient evidence to support causation. So they found that not only could Mr. Hollop not prove that he was disabled as of the time that he last worked, but they also agreed with the Worcester Retirement Board that there was insufficient evidence on causation. So what you can take away from this case is, as we often say, causation, all three issues, disability, permanence, and causations, are solely within the province of the Retirement Board. Often we hear some retirement boards or board members say, well, we're not doctors. Well, that's true. You're not a doctor. Judges and juries are not doctors either, yet they evaluate medical malpractice cases. In criminal cases, juries send people to prison for the rest of their life based on DNA evidence. You are the fact finder. It is your duty and obligation to evaluate the evidence. And in particular with causation, the medical panel is only opining whether it's medically possible that a particular event resulted in a permanent incapacity. You as a retirement board have to make that determination by a preponderance of the evidence. So to put that in percentage terms, a medical panel, when they say yes to causation, they're only saying there's a 1% chance that causation has been established, whereas you as a board have the requirement to say by a 51% chance that, well, probability actually, that causation has been established. So the board and we worked very hard on this case. There was a lot of evidence. There was a lot of medical reports. It went on for many years. But in the end, we're comfortable with the decision and obviously pleased with it. And this was the proverbial $1 million case. Mr. Hollop had, as I said, less than 2 years of creditable service. When he was injured, his workers' comp case was denied on appeal, so he was not going to ever attain enough creditable service to retire. And when you look at his age and life expectancy and what his accidental disability would have been, this case was clearly going to be a significant burden on the board's and the system's financial unfunded liability. Not that that's ever a reason to grant or deny a case, but it is a reality that you face when you are investing time and money into these cases. Mr. Hollop has filed an appeal into the Superior Court. We're confident that will prevail in this case, but as with the Bell case that I recently discussed, hopefully I'll be talking to you about this at a MACRS conference at some point in the future. Thanks so much.
Thank you, Michael. I'm going to ask you just to hang loose for 1 minute. Due to time constraints, we're going to have a few questions. We're going to limit the questions, and if your question is not answered, send an email to MACRS and we will get it to the right person to answer it. But Michael, I've received some questions for you. I'm going to give them to you all at once and you can answer, because some I think are very simple. The first question is, can the board hire their own physician for ordinary disability, or is it only for accidental and accidental death? Second question is, why did the Franklin board feel the need to go beyond the death certificate, the treating doctor's report, and PERAC's doctor in arriving at its decision goal? And the third question is, on the disability application, it says, I understand that if I give false or incomplete information, I may be subject to the application to civil and criminal penalties. What penalties can the board invoke, and has a retirement board done that before, to your knowledge?
So a board has the discretion to hire a physician to assist them with any disability or death case. The second question was, why did the board go beyond the death certificate, or feel the need to go beyond the death certificate and the treating doctor's report? So the death certificate in the Bell case clearly did not, at least from our lay perspective, and perhaps from my perspective in doing this for so long and looking at so many medical records, we understood that congestive heart failure is not coronary artery disease. And Dr. Giuliano testified the distinction between the two diagnoses during the Dalla hearing. The doctor's note that was provided with the application, while it was supporting of the claim, it didn't address the specific language that's required in the statute. The reason why the board went beyond first to PERAC for the single physician panel was, again, to allow Mrs. Bell every opportunity to prove her case. But secondarily, in anticipation of an appeal, when you appeal, it's a de novo appeal. So if we didn't go these extra steps, nothing prevented Mrs. Bell from bringing in another doctor or giving another opinion at DALA, and we wouldn't have anything at that point to rebut it. So that was why we went to PERAC first to get another opinion. Honestly, our belief was that the PERAC doctor would disagree with Mrs. Bell's doctor, simply because, again, looking at the evidence, looking at the diagnoses, it was very clear that he did not die of coronary artery disease, but the PERAC doctor did not give us that opinion. And in fact, as the litigation showed with the Superior Court decision, that opinion was flawed, as well as Dr. Campanelli's opinion. So that's why we ended up hiring an outside doctor to assist us with the process, and that turned out to be a benefit to us in terms of getting to the right decision. On the civil and criminal penalties, I am not aware of any case that has been successfully prosecuted for pension fraud. On the civil side, there is a provision in Chapter 32, Section 24, which allows certain civil penalties to be imposed for filing false statements. I'm also unaware of any cases that have occurred in that realm as well. Certainly there have been cases that have been pursued under that section for beneficiaries. For example, I'm aware of a couple cases where children had signed their parents' name, or the member or retiree's name, I should say, to the annual verification to continue receiving the payment when the recipient had already passed away. Those cases, there have been civil penalties and some prosecutions in those cases, but I'm not familiar with, and maybe Tom is aware, but I'm not familiar with any cases where someone has been successfully prosecuted or even charged with pension fraud for making a false statement on an application.
Thank you, Michael. Appreciate that. I am aware of one situation where a member was given a duplicate refund of accumulated deductions and refused to return the overpayment to the retirement board despite repeated contacts and requests to do so. The retirement board referred the matter to the municipal police department, and the police department brought charges against the former member for misappropriation of funds, and actually received a judgment from the court ordering the member to pay the retirement board those funds back. So there is some evidence, some cases where this does take place. So my next series of questions, and again, because of time constraints, I'm going to combine some of these questions. This is for Judith Corrigan. Judith, the first question is pretty simple. Are the terms permanent, temporary, provisional, intermittent, etc., substitute, are those terms defined anywhere?
I think that for sure, intermittent is not defined anywhere. Whoever is asking this question, I'll have to get back to you. I don't think they are, but I'm not sure.
Thank you. The second question is, a police officer wants to purchase his Ford 2B in time. In his first year, he made less than $5,000, and in the second year, he makes $7,000. Does he only get 1 year under 42B? And if so, how do I plot less than $5,000 time, if at all?
I assume this is after July 1st, 2009.
It does not say, but let's assume that.
Okay, so if it's after July 1st, 2009, under the Gomes decision, you have to have received $5,000 in a year to get the Section 42B time. So I would say as to the $7,000 a year time, sure, go ahead and grant a year under 42B. For the $5,000, how much did they receive in the first year? Less than 5. They cannot get the 42B time under that section. You know, remember, 42B is an augmented, beautiful benefit that gives you more creditable service to which you'd be otherwise entitled. If the person wants to pursue possibly getting his time under another section, which I indicated is pretty unlikely, he or she should do so.
Thank you, Judith. Another question for Judith. My nephew worked for the rec department for 4 summers. He only made $2,000 each summer. He is now a member of the retirement system. Can he buy back that time?
So going back to, and remember, anything I say could be revised and extended by PERAC later. You know, going back to what I said in my initial presentation, why was 410 inserted in the statute? I don't think it was to exclude your nephew from buying back his time. If he made $2,000 in the summer, he could have made over $5,000 working more months. So I think it would be fine to let him buy back that time.
Thank you, Judith. So our final question is going to be for both Matt and Judith. And while Judith is there, I'm going to have her chime in on this.
Okay.
So, my retirement board gives full credible service for working 20 hours or more per week. If I receive 2/3 pay under the federal law, shouldn't I still receive full credible service?
Well, I think Matt could answer that.
I think Tom might be able to, he can possibly elaborate as well. I would think that you would not get the full service, but it would depend on what scenario you're operating under for the 2X. If it's one of the first 3 scenarios in which you're getting 100% of your pay, then I think you would be okay. But if it's 2/3, then I think you could be out of luck. Tom and I were discussing this a few minutes ago, and I know this, obviously this is something that's still going to take some time to come up with a final decision. And Judith, I'm not sure if you have anything else to add to that.
I'm interested in a person being a full-time credible service for 20 hours a week. Does it say where this is from?
It does not.
Okay.
So I was less concerned with, I think there could be some degree of conflict between maybe some of the regulations that exist and the federal law currently.
So in the FCRA avenue, I think PERAC is pretty firm that it's going to be full-time credible service, but your 3 or 5 year average might be affected by the receipt of less than the full amount.
Thanks.
Well, thank you, Matt and Judith and Michael and Lisa. This was an excellent legal panel. I hope our audience enjoyed it as well. Don't forget that you're all registered here. You'll get the 3 credits if you're a board member. And I want to thank you all for your patience, for letting us sort of fumble around here initially with our Zoom presentation. I think this is going to be the wave of the future. And again, I'm grateful to MACRS and to Kathleen Kiley-Pichetti and John Brown and the rest of the MACRS e-board and officers for allowing us to create this legal panel. And before I leave, I'm just going to turn it over to Kathleen for some parting remarks. And again, the legal panel thanks you very much for your time and attention.
Thank you, Tom. Thank you to everyone. This does conclude our session for today. Again, thank you to our panelists, the Middlesex County Retirement Board, PERAC, our Communications Director, Melissa Hurley, and our sponsor, PTG. Please remember to complete the survey. We want your feedback to determine whether MACRS should hold more events like today. Until we meet again, keep washing your hands, wear your masks, and stay healthy. Thank you. Bye-bye.